Well, good morning, everyone, except on the East Coast where it's almost not morning. I'm David Glazer.
I'm Katie Hilton.
And we're here today for our very special webinar about the 2 midnight rule, a short stay update. It's so special that I'm delaying my trip to the Minnesota State Fair and Butter Sculptures to do this. Only, I think, 2 announcements that I can think of. So our next webinar is at the normal time, which is going to be Wednesday, September 11th, noon Central Time, 1 p.m. Eastern. You can calculate the rest from there. And that's going to be Katie Hilton and Briar Andreessen doing training on HIPAA. So it's designed to be something that you can show to employees and count it as HIPAA training on the new HIPAA requirements that kick in next month. Barring major changes, on our October webinar will be Compliance Plans Revisited, and we'll talk a bit about compliance. I guess the last announcement is, occasionally, I think the number one frustration people have on these webinars is occasionally the sound goes haywire. So don't forget, you always have the option of dialing in. If the speakers aren't working well on your computer, it's probably the internet. And you can use the 800 number that Robert Nelson is typing in the chat box. And that chat box is what you use for questions.
And you can also listen and watch the slides advance, the webinars on our SlideShare site, which is fairly new, but has all of our past webinars, and we'll have this webinar within 5 or so days from today.
And the nice thing about that is if you think this is decent, you can send it to anyone you want. And if you think it's crummy, you can even put a comment up there on how terrible it is and no one should watch it. Okay, so a friend of mine, John Weiss, commented that the 2 midnight rule sounded like it was going to be a part of the 50 Shades of Grey series. And I think he's right.
CMS is going for provocative.
Yeah, so we've got this new thing that came out. CMS now publishes kind of advanced copies of its rules. So the rule appears in the August 19th Federal Register. That was Monday. But you could get copies of it on August 2nd on their website. And it's going to be effective for admissions that happen on or after October 1st, 2013. As many of you may know, that's the beginning of the government's fiscal year. So a lot of fiscal stuff happens beginning in October. And one of the big things about this is the first regulation that actually addresses the definition of an inpatient for Medicare purposes. Some of you may have seen Katie and I, we did a webinar on short stays a year and a half ago, which I believe is on the SlideShare right now, so it will be a little outdated. But we went through there some of the other payers, including Medicaid, which does have a definition of inpatient. But this is the first time Medicare has a regulation dealing with the definition of inpatient. So a couple of highlights of this rule, and then one thing you're going to hear a lot. The new rule makes it extremely explicit that an inpatient is someone who's expected to be in the hospital for 2 midnights. And that expectation is key, and Katie and I are going to be stressing that. Katie in a second is going to walk through the current rule, and we'll contrast that to the change. But it's all about expectations. Charles Dickens would be, it's great expectations. Okay. Another change is that you have to have an admitting order and support for the rationale in the record. Now, many of you have heard us do our "if it isn't written, it wasn't done" spiel. And I think in some ways this really confirms the validity of that legal argument. Generally, the lack of some information in the medical record doesn't doom you to non-coverage. But now, as of October 1st, there's going to be an explicit documentation requirement. Explicit documentation requirements, to the best of my knowledge, occur only in a handful of places. It occurs in the teaching physician rule. It occurs for anesthesia. I think for some orders, but this is going to be another one. There has to be something in the medical record for coverage. And then it reinstates the 1-year timely filing requirement that Katie will be talking more about because I get too mad and lose my ability to speak. So to summarize, there are a couple of perspectives I would offer on this. I actually think this is mostly good. Put an asterisk there because I'll come to the bad in a minute. The first reason it's good, this is clear. We will talk about how you can explain this to people in just a few sentences, and that's something we didn't have before. Well, I would say actually, I think you could have explained the rule before in a few sentences.
But the government didn't get it.
Exactly. So we got that. Also, in a little bit, we'll talk about an interesting opportunity that may exist that didn't exist before that can enhance revenue. But there's obviously the big bad. you now need the 2 midnights will lower the number of things from what I think today. I think that there are things that today would be a reasonable inpatient admission that won't. And now Katie will explain a bit of that because she'll talk about the current rule.
All right. So as David said, right now, today, we don't have a regulation. We don't have a statute that talks about inpatient admissions.
And that was Katie's polite way of saying that when I used the word rule, I was bad. We don't have a rule. We have guidance.
We have guidance. And we have sort of a jumble of guidance. And as far as we've seen, CMS has not been very keen on understanding what its guidance was on this topic. But so I'm going to walk through what the guidance is now. And it's important to not totally blow off this pre-October guidance because you will still be using it and should still be using it when you appeal pre-October admissions that have been denied. So this is actually still helpful. So as a framework, what you're going to see in the next few slides is a bunch of manual language. And we've mostly quoted it, and I'll walk you through it. But what you're going to see is that there are 3, maybe 4 different tests for how CMS says you should determine who is an inpatient. So the first test, I've highlighted in blue here, says, generally, a patient is considered an inpatient if they are formally admitted as an inpatient. That's super helpful. With the expectation that he or she will remain at least overnight and occupy a bed. So the first test that we can identify is that if the patient's going to be there overnight, then they're an inpatient and you're good to go.
That's easy.
Easy enough. All right, so then notably in the same section of the manual, it goes on to say that the physician's responsible for the patient's care, and going to the purple language, the physicians should use a 24-hour period as a benchmark. That is, they should order admissions for patients who are expected to need hospital care for 24 hours or more, and then treat everyone else as an outpatient. Okay, so second standard, different than overnight. Overnight could be 10 p.m. to 6 a.m., and then the next standard here is 24 hours. So that's a little muddy. It's made it a little muddy here. And then just to make life interesting, we have the third test, which begins with the green language. However, the decision to admit a patient is a complex medical judgment, which can only be made after the physician has considered a number of factors, including the patient's medical history, current medical needs, types of facilities available, hospitals' bylaws and admission policies, and the appropriateness of treatment in each setting. And there are also a number of factors to consider when making this decision. Severity of signs and symptoms, predictability of something bad happening, will go on, need for diagnostic studies, availability of procedures when they come to the hospital. So
Katie, does that mean if the procedure isn't available, then it's okay to admit them?
You could make the argument. So this is really the third test that has emerged in just a few paragraphs of manual guidance. There's more. The fourth test or piece of guidance that currently exists is about when you have something called minor surgery or other treatment. Now, minor surgery is not a term of art for CMS. They haven't defined what's minor surgery. You're just apparently supposed to know. And so this last piece of guidance says that when a patient with a known diagnosis enters the hospital for a specific minor surgery or other treatment, and that is expected to keep them in the hospital for only a few hours, less than 24, so back to the time piece, then they're considered outpatients. And so basically we have these 4 guideposts from the guidance now. They're differing. We have overnight, we have more than 24 hours, we have who cares about time, it's just based on all these factors. And then, in these minor surgery cases, which, by the way, we haven't defined, if they're going to be there for a few hours, basically less than 24, then they're outpatients. So that's what we're working with right now.
So on the current stuff, and many of you have heard me talk, I don't understand how hospitals can be expected to refund money on short stay cases in the current climate, honestly. I think that guidance is soup, okay? And so I think if the government comes and asks you for money on a short stay case, I would tell them, basically, the only time I would be cutting a check is if the doctor didn't expect the patient to stay overnight.
Yep.
If the doctor didn't expect the patient to stay overnight, then we got a problem. But if the doctor expected him to stay overnight, I think there's a very strong argument you're okay, up till October. So things to note in there, boy, consistency is the hobgoblin of small minds. There's no consistency there at all. But it is worth noting, even before today, expectations control admission status. It isn't about what happens in the hospital. And let's say that again for emphasis. It isn't about what happens in the hospital. I had a call right before this rule came out with an attorney from the Justice Department who's working on a case, and he and I are disagreeing on how to interpret this particular thing. But one thing we agreed on was he said, yes, I do think that the admission status is prospective based on physician expectation. And so note, do the words interqual or milliman appear in anything Katie read? They don't.
And in fact, CMS has said in other forums, we don't endorse a specific tool. We don't require our contractors to use interqual, for example. And
we're going to talk more about that call, they've done it more than once, but in a call last week, they made it really clear that the idea of intensity of service and severity of illness, that's something that's not coming from CMS. That's not the yardstick they expect to use now or under the new rule effective October 1st. Okay?
So if you're seeing in your denials and quick decisions, etc., that the decision is basically based on the fact that nothing happened when the person stayed overnight, you should fight back with the current language.
And Katie has been fighting back on those things left and right. If you've got a situation where someone's saying, we don't think that what happened in the hospital was sufficient to support hospitalization, you should be calling Katie to appeal those things. Okay, so let's start looking at the new rule now, all right? And I think the easiest way to do this is just to look at the text. So the new rule, which is going to be in 412.3, says that for purposes of payment under Medicare Part A, you consider someone an inpatient of a hospital, and this applies also in critical access hospitals, if they're formally admitted as an inpatient pursuant to an order by a physician or other qualified practitioner. Okay, so first thing to note there, I guess it's physician or other qualified practitioner. Katie will talk more about that. Now, the physician order must be present in the medical record. So that's not a big change. That's kind of there now, at least arguably. But it's clear in the regulation. Yeah. And supported by the physician admission and progress notes. And that's definitely new.
Especially because they're calling out specific types of documentation, not just, the record. It's progress notes, which is the first time I've seen progress notes and specific documents like that used in the text of the regulation.
I would completely agree. Okay, so I think in addition to these orders, inpatient rehab facilities have to adhere to their admission requirements. That's not that big a deal. So Katie's going to take over the next part of this rule.
Okay, so you have to have an order, and so this is just about who it can be by. It can be by a physician or qualified licensed practitioner, but this is important. They absolutely have to have admitting privileges at the hospital when the order is made. The person who makes the order also has to be knowledgeable about the patient's hospital course. Important to kind of understand where that phrase is coming from. The proposed rule had said that the person who wrote the order had to be the patient's attending, the person who was assigned to that patient. They've backed off of that and said, okay, fine, it can be some other practitioner who has admitting privileges so long as they know what's going on. And you can't delegate it obviously to someone who doesn't have admitting privileges.
Okay. So the probably most important part of this is that the physician order has to be furnished at or before the time of admission. And they explain this during the call. So basically, let's say a patient comes in, you're not sure how long they're going to be in the hospital. You can place them in observation. And I'm going to try to avoid using the phrase admit to observation, but I'll probably slip at some point. So you place them in observation, and they spend the night. At the end of the night, the next morning, it's clear they're going to be in the hospital another night. According to the CMS call, and this open door forum, I believe, is available on the web, and the transcript from it is. And if you're interested in finding that, email Katie or I, and we will try to send you a link to it. But in this call, they made it quite clear that if the next morning you're going, okay, this person's spending the night, you now know they're going to spend their 2 nights in the hospital, you can admit the patient because you now have an expectation of 2 nights. You're going to be counting on that first night as part of the expectation, and so you will admit them. But, and I should have put this with days, they come into the hospital on Monday. You put them in observation. Tuesday morning, you want to admit them. They are now admitted on Tuesday. The fact that they were in the hospital all day Monday isn't material because the order has to be furnished before the time of admission. So they're admitted on Tuesday, and that's when things trigger. And I guess this is a good place. Okay, so if you've zoned out for a moment because that was frustrating, pay attention to this because you're going to want to hear it. The most interesting thing I got out of that call is a belief that if you if you place the person in observation on Monday, they spend the night, and you admit them Tuesday morning because they're going to spend Tuesday night in the hospital, you now are going to be able to bill for an observation day on Monday and a stay. Don't know how long. Yeah, go ahead, Katie.
Seems like double dipping. Seems like something CMS generally doesn't like.
I was shocked that they said this, but they were really clear in the call.
Straight out of their mouths.
That was okay. At least I guess I don't know if they said, but that's certainly how I heard the call really clearly, no doubt in my mind. So that is a giant positive. What it means is when in doubt, it's okay to use observation. See what happens that first night. And if they're going to spend the second night, you can upgrade and get a twofer.
So just to show you exactly where the magic 2 midnight language now appears. So 412.3, it's a new regulation. This is one of the more rambly regulations I've seen. It sort of reads like a manual. So bear with me here. So let's just look at the text. So except as specified in this other part that David's going to talk about, when a patient enters a hospital for a surgical procedure not specified by Medicare as inpatient only, so some other procedure, or a test, or any other treatment, and the physician or the treating individual, it doesn't have to be a physician, expects to keep the patient in the hospital for only a limited period of time that does not cross 2 midnights, then the services are generally inappropriate for inpatient admission under Part A. So they start out with the 2 midnights saying, if you don't cross 2 midnights, if the expectation is that they won't cross 2 midnights, then they're not going to be admitted as an inpatient. It's generally not appropriate. I will also point out that keeping the patient in the hospital, it isn't about keeping the patient in the hospital as an inpatient. It doesn't matter if they're using a bed, if they're sitting in a chair, if they're in observation, if they're in the inpatient area, in the 4 walls of the hospital. If you don't think that their stay is going to cross 2 midnights, then Medicare is going to say, okay, they're not supposed to be an inpatient.
So before we go, one interesting thing here is it's the negative statement.
Right.
It's not.
It starts out with the negative.
It's very crazy, but
it's odd. Then the next part of the regulation talks about when it would be appropriate to admit the patient, and that is when the treatment that they receive, the physician expects that the patient will need to stay across 2 midnights. So if that's the expectation, then that would be the time that you do the inpatient order. And as David said, you can kind of do this sort of, we're going to keep them in observation for a while until we think they're going to cross Tuesday's midnight. And then when we think that that's going to be the case, then the physician writes the order and they're an inpatient. Very importantly, this has to be all the factors that are causing the physician or admitting practitioner to get to this expectation have to be in the medical record. Obviously, we can argue till we're blue in the face for you that documentation doesn't matter, and if we can get testimony or whatever to make the argument that they should have been there, we'll make those arguments. But right now, starting in October, it's going to be really hard because those have to be in the medical record.
So that means physician education is going to be a giant part of this. And this is one area where I think this rule is better. Because I think you can educate physicians in it's the elevator speech, and Katie and I talked about this in our last thing, but now it's clearer. It's, doctor, you need to, here's your test. Do you think the person is going to be in the hospital on overnight twice, basically? I mean, so really, but 2 midnights.
2 midnights.
If you left at 1 a.m, it still would count. But,
right.
So overnight on 2 nights. If yes, you need to say explicitly why. So something like, the patient is coming in. I think they will be here, and they're coming in on Monday. I think they will be here until Wednesday morning because.
Right.
That's all you need.
And when you're writing the order, the regulation doesn't say this, people have asked the question, can you just say admit? Can the order say admit? I would just say admit as an inpatient. That's what the order should say. Don't try to get fancy or use special language. Just say admit as inpatient. And that should be enough.
Now, the rule, I think, should end here. It doesn't. It has part 2, which is the, remember, if actually we should back up. We're going to back up 2 slides here. Remember how this one started except as specified in paragraph E2? We had the rule. So here now we're going to look at what paragraph E2 says. If an unforeseen circumstance, such as a death or transfer, results in a shorter stay, the patient may be considered appropriately treated as an inpatient basis, and the hospital inpatient payment may be made under Medicare Part A. Now, to me, this is totally unnecessary because what the whole rule says is all about expects. And so
obviously you can't see an unforeseen circumstance.
Yeah, I mean, it's if it's unforeseen, that's the whole point. Now, what worries me is you can see them saying death and transfer are the two exceptions to that. Basically, they have to in fact be in the hospital for 2 midnights, and if they are in for less than 2 midnights and they didn't die or get transferred, it was an inappropriate stay. And there are hints of that from the phone call because they talk about how audits are going to be done, and they sort of suggest that they will be looking at stays that don't in fact cross 2 midnights. And we'll talk about this a little bit, but they talk about, Katie's going to talk a little bit about presumption. They have a benchmark and presumption and stuff like that. And sort of suggesting that there's like this rebuttable presumption that if they're not in 2 days, somehow the stay is tainted. That's not what the rule says.
Yeah, they've said they're going to direct their contractors to basically ignore stays that last 2 days or 2 midnights, and to rather focus attention on the 1-day stays. And just as David described, if you're using the strategy where you're going to wait to see if there's stay for another day, that might put you under a closer look by CMS. But if you have the order and if you have the factors supporting the expectation that you're going to stay at least 2 midnights, you should be able to defend that.
Yeah, and if you wait and see if they are in fact in 2 nights, you're good.
Right.
I mean, if they're in 2 nights, those stays pass muster. But if those shorter stays, I think under their rule, if you have the expectation, that expectation is reasonable, you're good to go.
Even if they get better.
But what they're hinting at is that they're going to ignore the expectation language and focus on, did they in fact stay 2 midnights, which is not what the rule says. Not going to spend much time on the medical review requirements. There's a physician acknowledgement that has to be there. And actually, this is interesting. I don't know if people know that this is in there now. This is not new. This physician acknowledgement, you need to go off and get a physician acknowledgement today that says, look, because payment is based on your principal and secondary diagnosis, this, and the doctor has to sign an acknowledgement, and that's currently in the regulations. So this language is not new.
Yeah, we wonder if they're going to be looking for this more, because there's an argument that if you don't have this at all, even now, you don't have a condition for payment, you shouldn't be getting paid. So
yeah, and
go check those.
Katie, do you want to explain quickly the condition of payment part?
Right. So there are certain rules that say you have to do these things in order to be enrolled in Medicare, and those are called conditions of participation. And so if something happens that you don't follow one of those, then we say, well, fine, we don't have to give money back, though, because those are just rules that we have to follow to be enrolled. But there are also rules that are called conditions of payment, where it's harder. The regulations basically say, in order to get paid, you have to do these 10 things. And it's very hard for us to say, if you didn't do one of the 10 things, you should still get paid. So query whether it will become more important to have proof of this acknowledgement now.
All right. So once again, this is not new. Right now, there is a rule that says when a claim is submitted, you have to have on file a signed acknowledgement that says this. I hope all hospitals are doing this,
Maybe
but
everyone does.
This is where us being lawyers, we're in the ivory tower. I don't know that people in fact do all this stuff. I bet someone does it, but it's worth knowing. And so I think that's enough on that. So Katie.
So another interesting piece of this regulation is that CMS has said in the rule that there's not going to be any weight given to the fact that the physician ordered the inpatient admission. So yes, they may have ordered it, but CMS is not going to say, well, because the physician ordered it, then we presume that it's okay. They're going to look at the documentation. They're going to look at whether that expectation of staying past over 2 midnights was reasonable. it's just really interesting that they put in this fact that there's no presumption and that they reference the Social Security Act, because in fact the act, the first sentence of the Social Security Act that sets out the Medicare program, says basically that no one, including the government, can interfere with a physician's judgment, and that is called the treating physician rule, the idea that the treating physician is presumed to be correct in determining what's reasonable and necessary. So people say that the treating physician rule is dead. It's still in the Social Security Act, so I'm going to keep using it. But interesting that they've put in this regulation that they're not going to, at least in acting, they're not going to allow a presumption to be made because the physician ordered it.
And I think trying to harmonize this this is really interesting because they talk about sort of this presumption, and I think what they're trying to say is that if a doctor just willy-nilly says everyone's going to be in 2 days, we're not going to let you get away with that. And I think that is somewhat fair. I think the doctor has to have an expectation that they're going to be in 2 nights. And you probably, under the actual wording of the regulation, could say with a straight face, if the doctor's that's an interesting question. If the doctor's expectation was unreasonable, where do you go? Because the actual text of the language is when a patient enters the hospital and the physician expects to keep the patient. It doesn't say
they have to be reasonable.
Reasonably expects. And if they really wanted it to be a reasonable expectation, they should have put the word reasonable in the regulation.
Yeah. That's why they rely on the factors in the medical record. They're going to use those to make sure that they're there.
So what I think they're getting at here is that they want to look at whether the physician's expectation was reasonable or not. And an interesting fight will be whether the regulation gives them the authority to do that or not. All right, this slide is rated X. We're back to the 2 midnights as being 50 Shades of Grey. So reading this rule was at times humbling. And at no point was it more humbling when I read the next couple of sentences. So under existing policy, all reasonable and necessary outpatient services that are furnished in a 3-day stay, and then the parentheses make things confusing, but for prospective payment hospitals, there's a 1-day bundling window. For every other hospital, it's a 3-day window. Including those requiring outpatient status may be billed on the 13X Part B outpatient type of bill, or TOB. And I came to this and I said, oh my God, I'm so stupid. Here's what I think I'm understanding now. So, and I should know this better than I do, but there is Part B payment, inpatient payment that's possible, and there's Part B outpatient payment that's possible. I did not realize there was Part B inpatient. That was kind of what I've been learning through this process. And let's see if we go into this next slide, this will help explain it. So services that require an outpatient status and can't be billed on a 12X, that's inpatient claim, which includes observation services, outpatient hospital visits, and outpatient diabetes management training, right, is the T, are payable if they were furnished to an outpatient during the 3 days payment window preceding the inpatient admission and are billed on a Part B outpatient claim. Okay.
So you need an explanation, as you've said.
Oh, art. Yeah. Yes. And this is just painful for me, but I think what they're trying to say is that if you've got observation services or an outpatient hospital visit or diabetes management training, those things, whether or not your inpatient stay is necessary, are covered as outpatient services. You bill them as an outpatient service on the 13X claim. And frankly, even if you subsequently were to decide that inpatient stay wasn't reasonable, it doesn't matter.
So keep doing what you're doing.
Yes.
Don't change because of this new rule.
Yeah. But it was just and it was just a humbling thing to me about how little I understand about the mechanics of the billing process. Now, a couple of giant things that came up in here. So one question that pervades back up a step. When a new regulation comes out, there's a thing called preamble. Preamble is text where when people have put in comments, CMS responds to them. And so there's a whole bunch of comment and response. And it's really interesting because you can get insight into CMS's perspective. So there were a bunch of comments from people that said, oh, come on. What do we do if we decide an inpatient stay is unnecessary, sometime in the future? And if we're going to make it outpatient, that can affect the beneficiary liability. What are we going to do? And can you please make it clear that we don't have to go get the increased coinsurance copayment from the beneficiary. Please make that clear, said many comments. And CMS helpfully said, we can't do that. The law doesn't allow us to do that. Which I
question that.
Yeah, I don't think that's true. But then they said, really, this is an OIG anti-kickback issue, so what you need to do is go ask the OIG.
Which is sort of hilarious, because if you're thinking about how you're trying to induce people to use your facility, the last way to do it is to order an inpatient admission that was unnecessary, and then find that out, and then go ask them for more money.
Yeah.
So I really don't think this is a kickback issue.
No. And so I'm just not worried about this at all. If you were to change status later on and decide you're not going after the beneficiary, I think the risk that you get in trouble for that decision is zero.
Yep.
I suppose my lawyer should never say that, but I just did.
We're going out on a limb today.
So that's the thing I'm not worried. CMS won't tell you it's okay. They'll tell you to go ask the OIG, but I think if you make that adjustment, you're fine. The other big issue, so this is one.
This makes David's blood boil.
Yeah, I was reading this on a plane, and I almost depressurized the plane. So over 300 commenters on the Part B inpatient billing proposed rule objected to the proposal that claims for billed Part B inpatient services would be rejected as untimely when those Part B claims are filed later than 1 calendar year after the date of service. One commenter supported the proposal.
Obviously not a hospital.
So the comments ran 300 to 1. So what did they do? They went with the 1.
Right. So basically, now, beginning with admissions dated 10/1/2013, if that inpatient admission is denied, you have to submit your outpatient bill to get the outpatient services paid within a year from the date. Now, that's fine if you figure out if the inpatient admission was improper before that 12 months runs. But as many of you, I'm sure, know, if you're appealing a denial of an inpatient admission, the appeals process, like the first stage of it, takes at least 3 months. I mean, 6 months at this point for many of them. So you're not likely to have a decision on that appeal until after the 12 months. Now, this was raised by the various 300 commenters, and CMS said, well, yeah, we get that, but sorry, we're not going to make an exception here. And this new rule should make things easier, which we're being optimistic. We're hoping that it will.
I agree
and I
with
think
that.
it will.
I think it will. I think we will be doing, right now there are a lot of appeals. I think 2 years out, we will be doing fewer appeals. And while I should be bummed about that from a work standpoint, I'm actually happy because I think it's better for society.
Right. Now, importantly, this 12-year billing requirement, or not 12-year, I wish, excuse me, 1 year billing requirement does not apply to those appeals for admissions that are pre-10/1/2013. So the situation here is basically you're undergoing a RAC audit, as many people are, and let's be honest, I don't think that CMS is going to get to the RACs within the next few months to help them understand how to properly review inpatient admissions before October 1st. So you're probably going to continue to get denials on those admissions, and you are going to want to continue, and you should appeal them, because I actually think your appeal is stronger now, which I'll explain in a little bit. So if you decide to appeal them, and you have a pending appeal where for an inpatient admission, but you want to be able to bill for the outpatient, say you feel better about the outpatient claim, you're not going to be subject to the 1 year time requirement. You're going to be subject to this ruling that CMS made a few months ago that said, if you have an inpatient admission you're appealing, and it's been denied and it's pending appeal, you can formally withdraw the appeal and submit the claim for the outpatient within 180 days from that withdrawal. So there's a lot of time frames here, but basically continue to appeal pre-10/1/2013 admissions and know that for those, you're not going to be subject to the 1 year timeline for billing.
So here's the 4-star question, Katie. After 10/1, if you appeal, you have an admission, it's denied, you appeal to an administrative law judge. Can the administrative law judge give you the, if they too deny the inpatient status, can they give you outpatient status?
Can they give you outpatient even though you're outside the 1 year time frame? We've certainly, the whole reason this time frame issue came up is because CMS does not like what the ALJs and, in fact, the Medicare Appeals Council, which is the higher level, they don't like what they're doing by giving, they're saying, hospital, you should get paid for the outpatient stuff, even if the inpatient was not right. I mean, you provided a service. And so we've seen ALJs bucking the system. I mean, maybe they'll change party lines, but it's still, I think, worth going for. These are not hard appeals to put together. They don't require a lot of time. So I say go for it.
All right. So now we've been talking a lot about admissions. I want to talk about a different kind of admission now, than admission from CMS. So we're going to, this is really interesting and I think really helpful for everyone who's got any sort of admission case, whether it's a short stay false claim investigation or, those of you who are still in the kyphoplasty investigation. Speaking of which, I saw today a physician made an individual settlement in a kyphoplasty case. So if you're still in the kyphoplasty thing, drop me a line.
And I'm going to put a plug in for David because for the people who are being investigated for kyphoplasty issues that he's representing have not settled, and many other people have, and there's a reason. It's because he has some really good arguments. So call him.
I'm blushing now. Okay, but speaking of admissions, this language I think is really helpful in short stay cases. So we expect these guidelines to reduce the volume of Part A claims denials and subsequent appeals because these guidelines provide additional clarification regarding the circumstances under which a beneficiary should be admitted as an inpatient and the criteria that will be used during the medical reviews. So let's put this, let's go to the next slide and then we'll put this in plain English. Although we believe our previous guidelines were clear,
you guys can be the judge of that.
We believe the revised guidelines will promote greater shared or mutual understanding between hospitals, physicians, and Medicare's review contractors. They're trying to put that we believe they were clear. Baloney. And that's why they're changing them, and they're kind of acknowledging it in here. And they recognize that if they say that it was unclear before, they've really made a mess out of all of the cases that are out there. But no reasonable person can think that that stuff was clear. Now, timing is everything. And this is all about expectations, all right? So here's kind of the language we alluded to earlier. Our previous guidance also provided for a 24-hour benchmark, instructing physicians that, in general, beneficiaries who need to stay in the hospital less than 24 hours may usually be treated as inpatients. That's not what it says. It said overnight. But let's give them this for a moment. Okay. Our proposed 2 midnight benchmark, which we now finalize, simply modifies our previous guidance to specify that the relevant 24 hours are those encompassed by 2 midnights, which I like. So it's a 24-hour window period, and it only starts at midnight.
So just forget the 24 hours after October 1.
Okay, but I'm not buying their statement that they were 24 hours before, but here is language everyone should circle. Contrary to the commenter's suggestions, we do not refer to level of care in guidance regarding hospital inpatient admission decisions. Rather, we've consistently provided physicians or nuclear fusion, with the aforementioned time-based admission framework to effectuate appropriate inpatient hospital admission decisions. So I didn't put the part that this was coming from. Well, here I'm going to go on in the ellipses. This is supported by recent findings in the Office of Inspector General report, and you may want to dig that report up. So I didn't put the comment that led into this, but the comment was about using tools like Interqual and the like. And what this statement makes crystal clear is that the focus on Interqual and Milliman for Medicare patients is misplaced. Now, does that mean those tools are useless? No. Why? Well, a couple of reasons. First of all, not every patient is a Medicare patient, and private payers, if they want to have tools like that, can. The second thing, and I think I may have mentioned this in that webinar 18 months ago, I have a theory that much of the use of Interqual isn't related to deciding when to admit a patient, but rather when to discharge a patient. Because the discharge part of things is an important question for a hospital, because you don't want to be accused of sending people home while they're still too ill. So you may, as part of your UR, want to use Interqual, but you're using it not to decide when a patient is an inpatient, but rather to decide when to send them home. It could not be clearer that the standard for admission status is an expectation, a temporal expectation by the physician. So time matters. Level and intensity of service doesn't. And we've been saying this for a while, and I think people have sort of looked at us a little askance. This makes it clear that's true. All right, Katie, bring us home.
So I mentioned this before. You can still appeal denials before 10/1/2013. You can appeal them afterwards, but you should still deal with those that have been denied before because, as we laid out, the pre-10/1/2013 guidance is really based on an expectation. And this new rule basically helps that argument. It says, our previous guidance was clear. This new rule is based on expectations. Our old guidance was based on expectations. So use that to your advantage to appeal those pre-10/1/2013 rulings, and don't be afraid of the 1-year filing requirement because for those appeals you're going to have an additional time.
Okay, we got a bunch of questions here, and you can feel free to keep firing them away. We'll take these as we go. I've got one to start. Do you want to start with Kate? Okay.
Go ahead.
So, if a patient is in observation one night and they're upgraded to inpatient as they're expected to stay another night, does the observation night count towards the 2 midnight requirement, or would the patient have to stay a third night to meet the 2 midnight rule? Great question.
Good question.
As answered by the CMS people on the Open Door Forum, that first night counts. Now, so you'll have a 2-night stay, but they only have a 1-day stay in the hospital. So what's weird about this is so for example, if you're counting for SNF eligibility, do you have a 3-day stay? They don't have a 3-day stay for purposes of SNF eligibility, which is kind of crazy. And I'm actually shocked they didn't fix that because that's been a source of great controversy. But for purposes of determining the admission, yes, that you have 2 nights and it counts.
Basically, you can base your expectation on what's happened. The fact that they've stayed there over 1 midnight and that they will need to stay there over the next midnight.
Well said.
All right, this question was very similar to the last. All right, this rule applies to all admissions, correct? Not just surgical admissions? Yes, we talked about surgery a lot, but this is for all admissions, not just surgery, just to be clear.
So, do you expect private payers to adopt Medicare's admission rule? If yes, when would you expect this to start? Well, it's funny that we use the word expect here. I don't know. I don't have the faintest idea. I mean, I can't predict what private payers will do. I will say that I don't think private payers have historically used Medicare's admission status till now. Whether they will suddenly say, wow, this is clear, I'm going for it, I don't know. So I don't, it's certainly possible. I don't know.
Okay, question that just came off. To clarify, is there a change finally that allows the outpatient stay included in the 2 midnight?
Actually, outpatient here, I think we're talking observation.
Observation stay included in the 2 midnight rule. So nursing home admissions have the required 3-day stay for their 100-day Medicare coverage. I'm not seeing it, but would like to be sure it's discussed by advocacy groups. They didn't fix that in this rule. So absolutely talk about it with advocacy groups because this is going to be something.
That's a source of tremendous trouble for people and really pretty much left. They acknowledge that the problem exists and they did nothing about it.
Right. So just to clarify, another question. When a patient has an outpatient stay that becomes an inpatient stay, CMS will allow the facility to bill the first day as both an inpatient and outpatient stay. So this is the question. If you have a patient hanging out in observation and then the physician decides, they're going to stay for a second midnight, and they write the inpatient order, it seems very clear to David and I, after listening to this Open Door Forum from CMS, that you can bill for the time up to the order as outpatient, and then the full inpatient DRG.
Yeah, and so let's first of all offer a clarification. The first day isn't both an inpatient and outpatient day, all right? So this is where it gets nuanced. That first day is an observation day, all right? But you have to think about this in how hospital stays get paid. It's a DRG. Once you're in, the number of days you're in is immaterial for every reason except that nursing home eligibility. But otherwise, whether it's a 1-day, 2-day, 3-day stay, we don't care, okay? So you get to bill the observation service and you get a stay. So yes, you get both of those is what they said in this call. Could that change? Darn straight it could change. But right now, that's what it is. And so that first day is not both. The first day is observation. But yes, you are billing an observation stay and a DRG. All right. If a procedure's on the inpatient-only list, and there's an example here that I'm not going to dare pronounce, even though it's a carotid endarterectomy, so I dared to go after it. Stays just one overnight. Can we still bill inpatient? They talked about this specifically, and
they said that for inpatient-only procedures.
I think that that's in.
Then
I think that's
inpatient
in.
admission.
I believe they said that. The rule does not say that.
No.
So the rule does not say that. I am 99% sure, and Katie seems to be confirming it, that during the open door forum, they specifically said if it's on the inpatient-only list, then you get to be in.
And what's interesting is that the rule, if you go back to the 2 midnight language in the rule, they talk about the 2 midnights for when a patient enters a hospital for a procedure not specified as inpatient only.
Oh, okay.
So that implies that if they
yeah.
do enter for an inpatient-only procedure, then you don't have to go through this rigmarole.
And I think the way I'd get there, too, by the way, would be to say that my admission order in this case would be, I am admitting them because they're on the inpatient-only list. So that's a good, we're going to get questions that was a good question. All right, we got a few more pouring in, and we've got a little bit more time, so we'll see.
Oh, that's a good question. Okay, here, I'll ask this one. A patient starts as inpatient with the expectation of a 2 midnight stay. But after the first midnight, it becomes obvious the patient will be discharged. So the MD physician decides to change the order to observation. When does the observation billing start? Can we bill the pre-observation order time as observation 2?
Well, here's my take on this. I don't think you should change it. I mean, Katie, let's see what you...
Yeah, if the physician had expected at one point when he made the order that the person was going to be there for 2 midnights and they just happen to get better, which hopefully they do. That's you've met the test. You should get the inpatient admission.
You're squarely in the unexpected stay. That's you expected. So I wouldn't make the change myself.
Yep.
You with me?
I am.
All right. You have another one? You want to?
Got a question about condition code 44.
All right, condition code 44, my fave. It makes me think of Chuck Foreman, for those of you who are old Viking fans. When the stay is changed from an inpatient to observation, you can't go back, but can only bill for the hours from the time the order is written to change the status. So why would they allow the opposite for this rule?
Common sense is not.
Don't ask why.
Yeah.
That's the best I can say on this is, condition code 44 has flummoxed me for years. It hasn't gotten better. I don't think it makes... I've never understood the principle behind it. I don't know the answer to this one.
No.
It's a good question. We're stumped.
Okay. Here's another hypo. If a patient has surgery on the observation day and is then admitted, so I'm assuming admitted as an inpatient, is the surgery on the observation day considered outpatient or inpatient? How would Part B charges be billed from the observation day? Well, this is David and I sigh because this is where our lawyerness doesn't help as much.
Okay.
So
I think they haven't been admitted yet when they had the surgery. So I think that it's pretty clear that surgery was because the admission doesn't take effect till the order. So I think that's pretty clear. It's a Part B charges for that first one.
Yeah.
All right. Do you foresee RACs doing reviews to determine what the physician documented the expectation for the stay, and will they disagree with the physician's decision? I think you can bet your bottom dollar. Bet your bottom dollar the answer to that is yes. I think they're going to look at what happened during the stay. I don't think they're going to focus on this expectation thing. I could be proven wrong, but I don't think I will.
All right. What is your guidance for patients that start as observation, but during the stay, they aren't safe to discharge and need skilled nursing facility services? Sorry, I'm reading through this. And they're ordered as an inpatient on day 2, anticipating it's going to take another 3 days to facilitate a transfer to the SNF. Would this patient qualify under the 3-day rule? I mean, I think the general answer is that if you have an expectation that they should be admitted as an inpatient for at least 2 midnights, then they will be an inpatient, and whether they stay there, the number of nights they stay there is going to be what counts for the SNF benefits.
So the important thing is the SNF benefit is not an expectation-driven rule. That's an actual number of nights. So it's easy to conflate those two. If they do in fact make it in 3 days, it would count. If a patient's admitted as observation and stays 1 midnight, should we upgrade the patient to inpatient if the patient needs to stay just 1 more night, but will probably be able to discharge then? Okay, so I guess we've kind of covered that one, but I think this is confusing, so let's cover it again. You can, yes, you can, and I would say should upgrade them to inpatient. It would be completely legitimate under the rule.
All right, question on physician education. Any suggestions on how we educate physicians on admitting patients to the inpatient as an inpatient if they expect 2 overnights for Medicare, and inpatient based on severity of illness and intensity of service for other payers? They're confused enough as it is. So they're saying our physicians don't really care at the time they're caring for the patient. They don't care who the payer is. They're trying to make a decision.
Amen.
It's a totally good question. I think the interqual Milliman stuff is still helpful in identifying the factors that would underlie a decision, an expectation that they would stay over 2 midnights. So I don't think they're mutually exclusive.
But one thing, from a practical level, first of all, and then you have to talk with your contracting people on this, you try to work hard with the private payers to get them to a simpler standard. So that's one practical thing you can do. That doesn't answer your education question at all. You can only educate so much. I don't think you can ever educate the physicians that well on interqual anyway, so I don't know that that's where I'd put my effort in. I'd put my effort into the Medicare stuff, which I think you can explain and is far more likely to be carefully scrutinized. So I would drive that home the most. That's where I'd stick my energy. But that the frustration of how do you deal with conflicting standards in the current environment is giant and very real. We're just going to do a couple more, and then we'll wrap things up here.
So a question about observation. Per CMS, observation is still up to 48 hours, correct?
Well, observation can go long. There's nothing... It can go longer.
They don't love it when it goes past 48 hours.
Yeah, there's some text in there. Actually, it's 48 or 72. I'm now rusty on whether they changed the text. But you can, if you, well, let's put it this way. This supersedes the observation guidance that's out there. Because the observation guidance is all manuals, and this is a regulation that's going to trump it. And so if you expect 2 midnights, you should admit the person.
Right. And you should know that there is no regulation that has an hour limit on observation.
And so actually, I would say at this point, there is no reason you should ever have a 3-day stay that's observation, because you'll have had, well, I take that back.
Yeah.
If at no point along the way did you think they were spending another, but really, after the 2nd night, you know that you expect them to have a 2-night stay, and you could admit them then.
Right.
So you'd always get an admission out of that. Here's one I can't answer, so I'll toss it out there. If we can bill for both observation and inpatient services during one date of service, what's the patient's copay? I don't know.
I don't know either.
So having been stumped and humiliated, I think this might be a good place to end it. So
it's worth mentioning that CMS in the Open Door Forum and already on many MAC contractors' websites, there have been questions and answers by various contractors, and there's going to be, I think, a host of manual guidance trickling out in the next few months.
They promised as much.
It's going to be there. I can't promise it'll be helpful. Let's hope that it will be, and that it'll be clear and concise, and everyone can just understand. But watch out for that. Watch out for issuances from your contractor. Look on their websites for FAQs. Just see how your contractor's handling this.
So remember, if you thought this was useful and there are other people in your organization that would benefit from it, sometime in the next week, I look over to Robert and I look over to Bruce. In the next week or so, it should be up on SlideShare, and you can forward it to people. And then September 11th on Wednesday, if you want to have people trained on HIPAA, go for it. So thank you so much for listening.
Thanks for indulging.
I'm going to go to the State Fair now.
All right.
Have a good day.